Imagine you're walking down the street, minding your own business. Suddenly, you're stopped, detained, and possibly handled violently while being frisked for weapons. This is commonly known as a stop and frisk, or legally, a Terry stop. A Terry stop is a police tactic that allows officers to briefly detain and question an individual they reasonably suspect is involved in criminal activity. If they also have a reasonable suspicion that the person is armed and dangerous, they can physically pat down the person's outer clothing. The primary purpose of this frisk is to discover weapons for officer safety, not to find drugs. This practice is controversial with critics, including the Vera Institute and Find Law, highlighting its potential for discriminatory application against people of color and its negative impact on police-community relations. Stop and frisk policies face strong criticism for the disproportionate impact on minority communities, often leading to increased police violence and psychological trauma. Studies suggest these policies are ineffective in reducing crime, with a minimal number of stops resulting in weapons seizures. Furthermore, the practice raises significant Fourth Amendment concerns regarding unreasonable searches and seizures. For a legal stop, officers need reasonable suspicion of criminal activity, a lower standard than probable cause is required for an arrest. Additionally, a frisk requires a separate and reasonable suspicion that the individual is armed and presently dangerous. Though the Supreme Court has not revisited stop and frisk laws since Terry v. Ohio, these policies, particularly in urban police forces across the United States, face considerable criticism in the 21st century for allegedly promoting racial profiling. A notable instance occurred in 2013 when a federal judge declared New York City's stop and frisk policies unconstitutional. This brings us to the Supreme Court's recent shadow docket and its implications for Fourth Amendment rights, specifically Noom v. Vasquez-Perdomo. This is a lawsuit filed in response to the ongoing ICE raids in Los Angeles. The case alleges Fourth Amendment violations due to who is specifically targeted. The claim is that the government is implementing a policy of stopping individuals without reasonable suspicion, and that these stops are based solely on broad profiles like apparent race, also known as not appearing Caucasian, assumed ethnicity, speaking Spanish or accented English, even someone's presence in certain locations like hardware store parking lots, and engagement in manual labor. The argument is that these factors cannot establish reasonable suspicion for illegal presence in the United States. Plaintiffs sought a temporary restraining order, a TRO, to halt raids based on these pretexts. The TRO was granted, but subsequently appealed to the Supreme Court's shadow docket. On Monday, the court voted to stay the order, meaning ICE can continue its raids despite allegations of Fourth Amendment violations. SCOTUS provided no explanation for granting the stay. There was no official opinion or statement release. Justice Kavanaugh, wrote his own concurring opinion. Of course, it doesn't represent the court's official reasoning, as the court clearly did not believe that allowing racial profiling on the streets of LA required any further justification. This becomes problematic when we review the Fourth Amendment. This amendment safeguards our rights to be free from unreasonable government searches and seizures. Much of the Supreme Court precedent defines what constitutes reasonable in various scenarios, including police stops. While there are different rules for vehicle stops versus public stops, existing case law, particularly regarding stop and frisks, has deemed explicitly racist practices as unreasonable searches. The court has previously stated that reasonable suspicion indicating a person is violating the law is required. In Justice Sotomayor's dissent, she states, "Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. and that the Fourth Amendment requires that seizure be reasonable. Officers may stop an individual only if they are aware of specific, articulable facts. Together with rational inferences from those facts that reasonably warrant suspicion that the individual may be illegally in the country, this requires more than an inchoate and unparticularized suspicion or hunch of criminal activity. Critically, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people. The concept of reasonable suspicion is a notably lower bar than probable cause. While this is true, it still demands specific individual facts targeting the person in question to suggest illegal presence. This is how the ICE raids are in direct conflict with the law in their mandate to broadly discriminate against an entire group. Normally, the Supreme Court is reluctant to grant emergency stays that overturn lower court decisions mid-case. Such decisions typically involve weighing the potential harm and benefits to each party. This decision shows a willingness to ignore precedent and the real-world consequences of their decisions. A lack of explanation in this ruling creates a dangerous precedent. It is unclear whether this decision now applies to all police stops, potentially allowing officers to use race, ethnicity, language, location, and occupation as pretext for stops, shifting the burden of proof onto the individual. The Supreme Court's silence on such critical matters offers zero guidance to lower courts, forcing them to guess at the impact this decision will have on how they are allowed to proceed in ongoing court cases. In the meantime, ICE can now grab anyone based on skin tone, their language, accent, and location. They can do so without any crime having been committed. The raids will undoubtedly cause citizens to be caught and possibly deported without any hope to prove their legal status in court. This will empower ICE and the federal government to disappear anyone they choose in broad daylight. But that may just be the whole point. That's all for this week. Until next time, remember, your voice is vital. Stand up, speak out, strike back. They don't know what they started. If you appreciate this content, please like, share, and subscribe. For updates, ring the bell. Your support truly helps the channel.
Take the